Good afternoon. Welcome to today's webinar. My name is James Vann. I'm an attorney with Vann Attorneys. We practice law in Raleigh, North Carolina. We cover the state of North Carolina, and today we're going to be talking about how important are corporate documents. We are so glad that you have been able to sign in today and look forward to our conversation. If you have questions, you may submit them either on the GoToWebinar control panel on your screen, or you may email those to webinar@vanattorneys.com. And we really would love to hear from you if you have a question. So we're going to be talking about corporate documents, why they're important, and the significance of those. We've sort of broken the documents up in three different ways. That is formational documents. How do you form a corporation? What does it take? The operational piece, as far as once the company gets started, how do you, what documents are necessary for the operation portion? And then the functional documents, once the company is running, what functions do they serve? So that's sort of how we have broken it out. Again, we're going to be looking at formational documents first. Really what that breaks down to is in North Carolina, the LLC, which is the Limited Liability Corporation, was authorized into existence in the early 1990s. And before that, it was all just C corporations. Some people, you might have heard a S corporation. And the S only identifies a corporation for tax purposes with the IRS. The sub S portion is actually sub S is a portion of the tax code. So if you hear someone say I'm a S corporation or sub S corporation, they are a regular C corporation with the identification from the Secretary of State of being taxed as the S corporation. The benefits of the S corp and the LLC is that they're taxed the same way, and that is all of the revenue and the expenses passed down to the owners of the business. So for formational documents, when you think about that, the articles of incorporation are for a C corp or an S corp, and articles of organization are for an LLC. That's not necessarily for you necessarily to remember, but just sort of helps you understand. So, and really what the importance of that is, it names what the corporate name is going to be. It says the name of the business is Vann Attorneys, PLLC, or whatever your name is. It also identifies the number of shares that are authorized to be issued. You don't have to issue that many, but that is the number of shares that have been authorized. And again, that's for a C corp or an S corp. The portion, if you're an LLC, what you would have you have 100% of the corporation of the LLC, and then you divvy up the LLC by percentages of the membership certificate. So, for example, you can't have any more than 100%. So you would break it up based upon the numbers of the owners. The articles of organization and incorporation also identifies who is going to serve as the registered agent. And the registered agent is either a person or another corporate entity that resides in the state of North Carolina that serves to accept official notification to the corporation. So you can say, I gave notice for whatever reason to the corporation. If you do that, you typically send it to the registered agent. And also the articles identifies where the principal office is and the mailing address. It's sort of asking the state for permission to work in the state of North Carolina by identifying these things. And then the Secretary of State, if the corporate name has not already been taken or is not too close to another name, and all of the other information has been provided that we've identified here, then the Secretary of State generally approves that, and they send you a article of incorporation or articles of organization. And again, the reason that's important is, let's just say that you and I decide to start a business, and we decided we're going to call it, say, ABC Corporation, Inc. We'll put an Inc. on the end, so ABC Corporation, Inc. We decided to do that. We're going to be selling products across the state of North Carolina. We could do that without filing with the Secretary of State, but you would not be an incorporation. Even though you have the name corporation in your name or Inc., that does not mean you are an incorporated business. It really probably would come down to being interpreted that you were or that we had a partnership versus a corporation. Also, partnerships can be filed with the Secretary of State. They're not as common, quite frankly, but they can be. But certainly corporations, if you want to serve and operate as a corporation, that's the purpose of doing it. And you use these documents to get that authorization. The real advantage of having articles formed or articles issued and a corporation being formed is it gives you the corporate shield, if you will, that others can't sue the owners, operators, maybe the board, and with the exception of very odd issues or odd decisions that are made by, say, the operational portion of the company, the board of directors, or the agents of the company. Barring some oddity in management, it shields the owners from liability. So that's one reason you would do that. So other formational documents, you have the bylaws for a corporation or the operating agreement for an LLC. And really, that's sort of the rules that the corporation has identified that they will operate and agree by, how they'll run. And those are really important documents, especially if you have more than one owner. It names the company name, the principal office, the shareholders or the members. It identifies any capital contributions that are being made. It identifies what the ownership level is. It also identifies the capital accounts. That is, as a corporation is operational, and capital accounts identify how much money, in essence, would have come down to the owners that hasn't been taken out of the company. Also identifies voting rights and potential control issues. The reason I say how important this is, anytime you have a corporate dispute with maybe the owners or the shareholders or members of the company, most people look to the bylaws and the operating agreement to identify sort of the starting place as to what the rules have been agreed to as far as how the company is going to run. We had a client a number of years ago that had a business. This person was the financier for the company, did not have the idea for the new business, but had the money behind it, but was willing to work in it to grow it. So this one person put all the money into it. The other person had the idea, had already been doing the business, but had not incorporated. And our client wanted to make sure that they were protected in case something happened in decision making, so that this person who was the financier for the company would be protected. So in the operating agreement, we put in the language that for all financial decisions, that our client would have to approve that. And again, it goes back to what the ownership control is and the voting rights. They went in, I want to say they may have been 50-50, which, again, we'll talk about that in a little bit, which is not a great idea generally. But this client said, hey, look, I can't afford to have problems and not be able to get my money back out. And, she had a real gut feel about her business opportunity, and it came to fruition. They eventually got off on bad terms, and we were able to use the operating agreement in court to basically take the checkbook out of the other company, out of the other members' hands. They had to relinquish all control for financial decisions to our client, which helped because this person had the financial background to make sure that the company ran better. Thankfully, that person got their money back, which is even better. Did not lose all of it. So the reason I say that, and I could give you other examples, look at what the bylaws say or the operating agreement. If you're investing in a company or if you're going into a company with someone else, make sure you've read that and understand it. It really is important. And it's certainly when it comes down to ownership, if there are more than two people, or if there's more than one person, then there's at least two in the corporation. What happens if they say, look, we want to be 50-50 ownership. I'll own 50%, that other person will own 50%. How does that parlay into decision making? it really gets tough because let's say, for example, right now everybody's got, we're looking at roses and everything's wonderful about how the company's going to operate. But if for some reason, and it will happen, you get to an issue and the two people cannot agree on how they make a decision, what do you do? And if the operating agreement or the bylaws do not identify that, then you've got to figure that out. I've had another client that I've represented a number of years. They were 50-50 in their business, incredibly wonderfully talented people in what they did. And they got along probably 75% of the time without any problems. The other 25% was World War III. And they were 50-50. They couldn't vote each other, out of the situation. Every time they voted, it came up 50-50. And so the challenge was, what do you do? Thankfully, those decisions did not cripple the company, but sometimes that can happen. Figure that out early before you enter into these agreements so that you can, if you got to go in 50-50, so that you can figure out how you're going to have disputes resolved. Voting rights, the same thing, sort of goes hand in hand. We just did one for another corporation where there was one guy, our primary client, who, again, was the financing background of the company, and he wanted to be able to control the company. So we put that into the operating agreement and the bylaws. If that's not in there, it really, you look back to what the agreement says. If the agreement does not identify it, then you have to go back to state statute. That's not going to be a ton of help to you, generally speaking. And let me just plug this in right now. And again, I'm not saying this as a commercial for us or any other lawyer. Anybody can go to online legal resources now and form a corporation, and they're pretty inexpensive to do. You may get a set of bylaws, or you may be getting an operating agreement with it. Generally speaking, my advice would be, what money you save, you may probably wind up spending that plus a multiple later to fix the problems that have not been identified in those. I'm not knocking the online groups, but they're generally, it's a cookie cutter mentality. They're not applying it to a particular company. So just be really careful in doing that. So again, we talked about the control issue. That's generally a big one. Also, the bylaws and the operating agreement generally regard how the board of directors are elected, how the company is going to be managed, and when there would be distributions or dividends. So, what's the significance if you're going to have a board of directors? What's that significance? Well, the owners appoint the board, and the board generally hires the employees or hires the staff of the company to set the management and the operation of the company. So if you don't like the way the company is being run as an owner, then you probably direct the board of directors to do something different. And again, being on the board goes back to the voting control. So that's why that's so important. Also, it identifies the stock certificates and membership certificates of a corporation. So you want to make sure that you have stock certificates if it's an if it's a C Corp or S Corp, and your membership certificates if it's a LLC. And a lot of times, again, if you buy those things online, you may or may not get those. So you do need them. So let's look at the operational part for a little bit. Why are these important? All of this is important and we'll talk about this sort of at the end, but to prove that you are actually a corporation, that you have set up the programs necessary for the company to operate, to be functional, operational, and the minutes is a report of when the shareholders meet or the members meet or the board of directors meets. Why is that important? Well, you got to be able to document what was said, what was agreed to, and what direction the company is moving into. We just had a recent issue with some clients that formed the corporation, and everybody obviously was in agreement. Everything was roses. Everything was looking really good, feeling good. They didn't ask the questions, well, what if? How do you fix this? What do you do about that? And in the minutes, they met a lot. because the company was a startup, they met a lot. Company did not have great minutes necessarily to really identify what they agreed to. And had they had that, it would have made the decisions or the issues that we ultimately put in front of the court a whole lot easier to resolve. So the minutes provides the proof of what was said and what was agreed to. Obviously, you got to give notice of the meetings. We've had some situations where one comes to mind. It's a family business. The members, the owners of the company, do not get along, and they're all family, and they don't want to meet. So we had to call a meeting on behalf of our client to have a meeting of the members of the company. And so you have to look to that and say, how do you do that? What's the procedure and the policy and procedures that are set forth in the operational part? How do you call a meeting of the owner? So you have to do the notice, but again, it's the shareholders and members that are driving those decisions a lot of times, and you got to make sure that you have that in your documentation. Same thing for a board of directors meeting. You got to have minutes, because for example, you might make a decision to buy a piece of property. Later on, you go, hey, look, we didn't put that in the minutes. It should have been in the minutes. We also get this question a lot. What happens? We've got some minutes, they've never been formalized. We've been doing this for 3 years, and we just never formalized them. That's okay. We can help you, or somebody else can help you get them in a formal manner to put them in your notebook or corporate documentation so that you have them all together. Obviously, also, it helps with accounting purposes or accounting issues. If you have some major, say, renovation, or you're buying equipment, or you're doing something to property that you own, or you're buying assets, then you need to have that in your minutes, but also it helps to document that for your accountant for accounting purposes. So those are some issues there that you want to make sure that you're looking at. So functional documents, what does that look like? Well, these are documents that are requested by others that would document the corporate agreements in operation. For example, you need to send documents to the Secretary of State. Every year, if you're a C Corp or S Corp or LLC, and in North Carolina, you are required to send to the Secretary of State of North Carolina an annual report. And there's a small fee you have to pay, but it basically says, hey, we're still here. These are the officers. This is our principal address. And it's really an easy process, but a lot of times business owners are so focused on operation of the business that they forget to do that. So that's certainly one of them. But again, the reason that's important is you go back and sometimes you can put the pieces back together if you don't have the good documentation early to tell how the company's running or how it's functioning. Also, sometimes you've got to notify the Department of Revenue within North Carolina on certain issues. Again, that's more evidence, again, of what the corporate documents are or what the agreements are. Sometimes banks require to see the operating agreement or the bylaws, or some of the minutes, maybe if the company's borrowing money to buy assets, or making say an equity line, or they need some kind of line of credit. Same thing with vendors and licensing agreements. We have a case that is ongoing where there are multiple members of a company, and they're in dispute about the ownership level. And you would think, well, didn't y'all know that? Well, yeah, they did. Again, everything was roses. Everything was really pretty. They're all making money. But when the downturn in the economy came, they started fighting each other because they weren't making the same amount of money. And now the issue is, well, who owns what percentage or what part of the company? And unfortunately, they didn't do a great job of documentation when they first started the company. So now we actually are reaching out to the banks, the vendors, and other areas to see if we can put those pieces together, because we know they identify that early on. But that's a huge, huge help if you can have that early on. So looking at the functional documents, why is it important to follow the corporate formalities? this is what I said we would talk about in just a few minutes. Following the corporate formalities gives you the protection if you're the owner and potentially the board of directors for the corporate shield. That is, people should not be able to sue you individually, but might sue the corporation if they've got a dispute, but should not reach to the owners. And by having these documents, it shows that you're setting up the corporate formalities. Quite often when we get into litigation, and other lawyers, I think, probably do the same thing, we go to look for the corporate documents. Especially if it's a small business or family business, these are things that have not been taken good care of. And so it generally shows that it's really not a company, but it's more of a pseudo operation of making it look like a company, but it's really individuals that are making all the decisions, and they're just running it themselves. Are you operating as a business or a pseudo company? Again, it sort of goes back to the same thing, but is this really a company, or is this more an individual that's sort of using the corporation to benefit themselves 100% only? So again, looking at that, company bank record, same thing. If you were to go to a company, say a family business or a small business, and look at their corporate bank records, would it be so confusing as that you would not be able to tell what was the corporate side versus their individual side? You know, is the company paying for say all the cellular bills of their family? Is the company paying for all of the internet at homes? Is the company paying for cable at all the owners' homes? Is it paying for the grocery bills, the laundry bills? You know, you just keep unrolling that. Does that indicate that the company really is not a true corporation, but really sort of a pass-through? And the reason I bring those things to your attention is a lot of times that's how people will try to pierce the corporate veil. Is they're saying this really is not a corporation, it's really more of a pseudo company that the individuals or the owners have set up. It's a fraud, it's a fake, and then they can try to get to you personally. We had an issue a number of years ago where we were suing this company. Dad had run the company very, very well. He died unexpectedly. Sons took it over, and the financial woes started happening. Our client was owed a lot of money. We sued. I think we got a judgment and started digging into the company records. And what we found out was the company had bought cars for all of the owners. When the company paid for the cars, but the cars were titled in the individuals' names. The company was also paying for all the fuel and also for all of the insurance for the cars. And not all the not all the people they bought cars for worked for the company. That just sort of gives you a flavor of what they were doing. They were sucking all the cash out of the company for their individual benefits. Did not help the company at all. And there were some other charges like that. But we threatened, hey, look, we're going to pierce the corporate veil and come after you individually, because they all had tons of assets personally. Same thing for company assets. Is the company buying assets that really belong to the owner or to the owners? Do the assets or do the expenditures really serve as a company function, or is that just a benefit for the owner? Now, we all know when you own a company, there are huge benefits tax-wise, but also asset-wise. But obviously, there's there's the area that's approved, and that's the gray area, and then there's the line that you don't want to cross over. So we try to remind our business clients to, when they set up their corporate documents or set up their companies, to make sure that you know where that line is and then back off of it so that you don't cross it. And so that's the reason that the corporate documents are important. The foundational documents, the forming documents, the functional documents, doing all of this helps to protect the owners to make sure that the company continues in operation and hopefully avoids the potential for being sued individually for trying to pierce the corporate veil. So hopefully that makes sense. If y'all have got questions, please feel free to send them in, either using the GoTo webinar control panel, or you can send it in by email. and we'll be glad to identify those for you. Hopefully this has been helpful to you. We get a lot of questions about corporations and companies and how they work and operate, and can I get sued for this or for that? So we'll be glad to identify any or answer any questions you identify. So if you have any questions, let us know. If you've not connected with us online using social media like Twitter or LinkedIn and stuff, I wish you would. I'd love to do that. And if we can help you, please reach out to us. We look forward to hopefully joining with you on our next webinar, and I look forward to serving you in the future. Thank you so much.